Hello everyone, welcome back. So we were discussing a very important concept, which is that not all agreements are contracts, correct? And only those agreements are contracts which fulfill certain conditions. So we had seen that agreement plus fulfillment of certain conditions is what will give you a valid contract. And this is a key thing that you have to always remember, that just because there is an agreement, it doesn't mean that you have a contract in place. An agreement needs to meet certain conditions in order for the agreement to become a contract. And we saw a few conditions in the last few classes. What are these conditions? The first condition that we had seen was competency of parties. And what had I told you with respect to competency? We had discussed that the law requires both parties to an agreement to be competent to enter into the agreement, right? So there are two parties to an agreement. All of us are aware of this: offerer and offeree. Law wants both the offerer and the offeree to be competent to enter into the agreement. And law also gives an example of who all are not competent. So what did we discuss here? Law says incompetent parties are: number one, minors. With respect to minors, we saw that an agreement with a minor is void ab initio, correct? It is not enforceable from the beginning. And there is only one exception, which is an agreement for the necessities of the minor. Second example of an incompetent person that we had seen was a person of unsound mind. And the person should be of unsound mind at the time when the agreement is being entered into. Okay. Law does not care about the unsoundness in general. For example, let's say somebody is medically unsound and is mentally ill. In medical terms, law is not concerned about what medical science has to say about the unsoundness of a person. All that the law checks is whether, when the agreement was entered into at that point of time, was this person of a sound mind or unsound mind? And in legal terms, it is known as legal unsoundness. Okay. And third category of incompetent person is persons prohibited by law. And I had given you a few examples. For example, Vijay Mallya. Let's say Vijay Mallya has taken a huge amount of loan, and despite having the capability to repay the loan, he fled. He fled from the country, and he decided not to repay the loan. So let's say if the government passes a law saying that Vijay Mallya and people like Vijay Mallya become willful defaulter. They have willfully defaulted repayment on their loan, and therefore these categories of people cannot be given any further loan. And loan, we know loan is also a type of an agreement between a lender and a borrower, correct? So if the government or a law clearly says that certain categories of people cannot enter into a loan agreement or cannot avail loan, it means that government has prohibited those people from entering into an agreement. Another example that we had seen was that of Ajmal Kasab. Let's say if people like Ajmal Kasab who commit heinous crimes, and the government says that these kinds of people who are enemies of India cannot enter into an agreement with Indian citizens, then we would clearly know that those types of people are incompetent for the purpose of formation of a contract. Okay. So the first condition was competency of parties. Second condition we saw, and that was free consent. In simple terms, it means that both the offerer and the offeree should decide voluntarily to enter into the agreement. They should not enter into an agreement because somebody is forcing them to enter into the agreement, or because somebody has cheated them. We saw 4-5 categories here, and I told you that free consent means that none of the following elements exists: coercion, meaning force. In simple terms, I'm writing, I've already explained all these things in detail. This is just a quick summary. Undue influence, where one party is in a position to dominate the will of the other party and misuses his authority. Fraud, misrepresentation, and mistake. Alright? Fraud was undue influence, misuse of one's authority. So the relationship between the parties is such that one party is in a position to dominate the will of the other party. Doctor, patient, father, son, lawyer, client, teacher, student, correct? And the party who is in a dominating position misuses his authority. Fraud is intentional cheating. Okay? When you cheat somebody intentionally, that is fraud. Misrepresentation, unintentional cheating. In misrepresentation also, the other party gets deceived, but the deception is unintentional. BMW example that I had given you. I have a BMW car which is a duplicate BMW, but I myself do not know that it is a duplicate car. And you want to buy my car. You think it is an original BMW. So I sell the car to you. Is it fraud? The answer is no, because I was not aware of the fact that it is a duplicate. So there was no intention on my part to cheat you. It is therefore misrepresentation. Unintentional cheating. Mistake, when both parties are under a mistake as to the essential fact of the agreement. And the example that we had seen was that of the landmark case, where there are two parties, seller and buyer. The seller has a horse and a car. Both are called Swift. And the buyer wants to purchase Swift. Buyer does not clarify as to which Swift he wants to buy, whether he wants to buy the horse Swift or the car Swift. And seller thinks that the buyer wants to buy the horse Swift. However, in his mind, the buyer wanted to buy the car Swift. So in this case, both the parties, the buyer and the seller, are under a mistake. And mistake as to what? Mistake as to the essential fact of the agreement. Alright? And therefore, and we also saw that in first four scenarios, coercion, undue influence, fraud and misrepresentation, the agreement becomes voidable. And in the last category, mistake, the agreement becomes void. Okay, and by now we are very clear about the difference between voidable and void. I won't repeat it. You can go back to the previous classes if you want to understand the meaning of these two terms. So we have seen two conditions so far: competency and free consent. Third condition for an agreement to become a contract is lawful consideration and lawful object. And we have discussed this partially when we were discussing consideration. But before we understand this condition, first question: what is the meaning of consideration? We have discussed this in great detail. So tell me, what is consideration? I told you that consideration is price of the promise. Okay? Or let me simplify this even further. In an agreement, there are two parties, right? A and B, offerer and offeree. Both the parties promise to do something, correct? You will never see that only one party is making a promise to the other and the other party is not doing anything. Both the parties have to make promises, okay, to do something or not to do something. So the promises will be exchanged. And consideration, I just told you, is price of the promise. What is the price of the promise? So let's say if I want to sell my pen to you, okay, I promise to sell my pen to you and you promise to buy the pen from me at rupees 10. Okay, so my promise is to sell the pen to you. What is the price of my promise? The price of my promise is rupees 10 because you will have to pay rupees 10 for the pen, correct? And what is your promise? Your promise is to pay rupees 10. And what is the price of that? What do you want in return for rupees 10? You want the pen. So consideration is price of the promise. Or in other words, you can say that what is it that the party is offering? In pen example, I am offering to give you the pen. That is the consideration to be paid by me, to be provided by me. You are offering to give me rupees 10. So that is the consideration being provided by you. So whenever you see consideration, just think of two terms, price of the promise and what each party gives to the other. Okay. And so in this context, what do you think would be the meaning of lawful consideration? The word lawful simply means not illegal. Something which is not illegal is lawful. Okay? Or in other words, something which is not against the law is lawful. So for contract formation, we saw the condition. The condition is that the consideration has to be lawful. When is consideration lawful? When is consideration lawful? If I ask you that, what will be your simple answer? You would simply say, when consideration is not illegal. Now think of a scenario where consideration can become illegal. But before that, you can think of the pen example that I just gave. Consideration that I am giving to you is pen, correct? And the consideration that you are giving is rupees 10. Is the consideration legal or illegal here? It's clearly legal because the law no law says that giving pen to somebody is illegal. And no law says that giving rupees 10 to somebody is illegal. Therefore, in the pen example, the consideration is perfectly legal, okay? And or lawful. Now think of a scenario where consideration can be illegal. And I've already given an example of unlawful consideration way back in our previous lectures. Do you remember this term, bribe? Think of a scenario where you are not able to clear CLAT, but you have a lot of money. So you make an offer to NLSIU that if NLSIU gives you a seat for the BA/LLB course, you will give rupees 10 lakhs to NLSIU. What is the consideration to be given by NLSIU? What is NLSIU giving you? NLSIU is giving you a seat. Consideration by NLSIU is a seat for the BA/LLB course. What is the consideration to be given by you? Rupees 10 lakh. Now, I told you that the consideration has to be lawful, or in other words, it cannot be illegal. Now, just check whether the consideration here is illegal or not. If NLSIU gives you a seat in exchange for rupees 10 lakh, is that legal or illegal? Do we have any law in India which says that giving this kind of an arrangement is not legal? Do we have any such law? Even if you don't know about any such law, logically you will be able to say that anybody who wants to study at NLSIU has to give an exam. Now, if NLSIU starts giving seats to someone and takes money in exchange for the seat, that has to be an illegal activity, right? Logically, anybody can say that. So this will be illegal. The consideration, which is the seat to be given in exchange for rupees 10 lakh, is illegal consideration. Similarly, you are giving 10 lakhs to NLSIU in exchange for a seat. What is it? It is a bribe. You are bribing NLSIU. And bribing somebody is illegal. And therefore, in this case, the consideration is unlawful. So whenever you have to determine whether the consideration is lawful or unlawful, first find out what is the consideration. That is step one. And second step would be to check whether the consideration is legal or illegal. If the consideration is legal, no problem. It is lawful. If the consideration is illegal, then you have to clearly call it out and say that, look, the consideration is unlawful and therefore not valid. So that is the meaning of lawful consideration. The second part of this condition is lawful object. What is the meaning of object here in this context? Here object means objective of the agreement, objective or purpose of the agreement. Okay, again, like lawful consideration, if you have to decide whether the object is lawful or unlawful, what is the first step that you will take? The first step is to find the object or purpose of the agreement. Correct? Now, how would you find the object or purpose of the agreement? Let's take an example and understand how. And what should we look for whenever we come across an agreement? Every agreement has a purpose, correct? Otherwise, why would people want to enter into an agreement? They want to achieve something, and they want to achieve that something. They want to achieve whatever they want to achieve. They want to do that with the help of an agreement. An agreement is a means to an end. Okay, let's say you want to buy a house. How will you buy a house? You know that you will need to enter into an agreement to buy the house. So agreement helps you buy the house. Agreement is not the end goal. Agreement is not your end objective. Your end objective is to buy the house. But to buy the house, you know that you will have to do an agreement. So if I ask you, what is the purpose of the agreement? In this scenario, you will say the purpose is to buy the house. All right. Let's take another example. There are two parties, A and B. A gives rupees 10 lakh to B. And why is A giving 10 lakh rupees to B? Because A has given a task to B. What is the task? Task is B is supposed to kill C. Okay, this 10 lakh rupees is to do that task. Is there an agreement here? The answer is yes, because both the parties are agreeing to do something. Both of them are promising to do something for each other, correct? A has promised to give rupees 10 lakhs. B has promised to kill C. What is the purpose of this agreement? If I were to ask you, what is the object or purpose of this agreement? What will be your answer? Your answer will be the purpose or object is to kill C, correct? Now that was step one. If you remember, that was the step one, to find the object or purpose. Now we will come to step two. Step two is to see whether the object or purpose is lawful or unlawful. And you will have to apply the same logic that you applied to consideration. Lawful is something that is not against the law, and unlawful is something which is illegal, which is against the law. Now, killing C, is it lawful or unlawful? Lawful or unlawful? And I just told you, to determine whether something is lawful or unlawful, you just have to check one thing, whether it is against the law or it is not against the law. If it is against the law, then it becomes unlawful. If it is against the law, then it is unlawful. And if it is not against the law, then it is lawful. Now apply this to our example. Killing C. What do you think? Is killing someone against the law or not against the law? It's quite simple. If you kill someone, that is an act against the law, and therefore killing C is unlawful. And hence we have the object here is unlawful object. And therefore this agreement is not valid. Alright, I hope you understood the meaning of lawful consideration and lawful object, and I have told you to identify as to when consideration and object are lawful or unlawful in very simple terms. Alright, now we will just see what is the effect of lawful consideration, effect of unlawful consideration and unlawful object. Now, once you have figured out that, okay, unlawful, there is unlawful consideration or unlawful object. And remember, the word used is and, please note, which means both the object and consideration need to be lawful. That is the condition. If any of these elements, object or consideration, is unlawful, then the condition is not satisfied. Okay, so for example, if you have a lawful object but unlawful consideration, you can safely say that the condition is not satisfied and therefore this is not a contract. Similarly, if the consideration is lawful but object is unlawful, then also you can say. So you should always apply your mind and think in this direction, that I need both lawful object and lawful consideration. And if any of these elements is missing, then there is no contract. Now, what will be the effect once you've identified that there is unlawful consideration or unlawful object or both unlawful object and unlawful consideration? Then what happens to this kind of agreement? Does it become void? Does it become voidable? Does it become something else? Your answer would be, if the object or consideration is unlawful, agreement becomes void. All right, not voidable. Please remember, this agreement is unenforceable from the beginning. Void, unenforceable, and therefore this kind of an agreement does not become a contract. I hope you understand that. So now we have covered 3 conditions which are required for an agreement to become a contract. Tomorrow we are going to look at the last condition, which is, the last condition says that there are certain agreements which are expressly declared to be void under Indian Contract Act. Your agreement should not fall under those categories. If your agreement falls under those categories which are specifically mentioned in the Indian Contract Act as void, then your agreement does not become a contract. So that is the last condition which we are going to discuss tomorrow, and that will bring an end to the series on how does an agreement become a contract. So please do attend, and thereafter we will discuss some specific types of agreements or contracts under Indian Contract Act. All right. Okay. Thank you so much.